For the first time in history, a nation's leaders would stand trial for crimes against humanity, not as military losers to be executed on the battlefield, but as defendants in a courtroom with rules of evidence, witness testimony, and legal procedure. 24 of Nazi Germany's most powerful men sat in the dock at Nuremberg. Hermann Göring, Rudolf Hess, Albert Speer, Joachim von Ribbentrop, men who had shaped Nazi policy at the highest levels. What would determine their fate? Not just documents or photographs, but the voices of 3,000 survivors who testified about what these men's decisions had cost them. May 8, 1945. Germany surrenders unconditionally. The war in Europe is over. The full scale of Nazi atrocities is beginning to emerge. Photographic evidence, documentary footage, survivor testimonies. The world realizes that what the Nazis had done exceeded even the darkest imaginings of wartime propaganda. But the Allies face an unprecedented problem. How do you prosecute the leaders of a defeated nation? History had never dealt with this before. After previous wars, leaders who lost were often executed summarily or left to flee. But this time was different. The scale of the crimes was different. The need for accountability was different. The Allies decide on a trial, not an execution, not a show trial designed to humiliate the Germans, but a real trial with rules of evidence, witness testimony, and legal procedure. It would be held in Nuremberg, a city that had been a symbolic center of Nazi power, home to the massive rallies where Hitler had addressed hundreds of thousands of supporters. Now, Nuremberg would be the site of something revolutionary, the first trial of a nation's leaders for crimes against humanity. The first trial where survivor testimony would carry the weight of legal evidence. The first trial where the voices of victims would determine the fate of the powerful. The trial would last 10 months. Hundreds of witnesses would testify. Thousands of documents would be introduced as evidence. And the verdicts would establish legal precedents that would shape international law for the rest of the 20th century and beyond. But none of this would have been possible without the testimony of survivors. The 3,000 survivors who testified at Nuremberg came from across Nazi-occupied Europe. Some had survived concentration camps. Others had witnessed massacres. Still others had lost entire families and were the sole surviving members of their communities. They came from Poland, Germany, France, Yugoslavia, the Soviet Union, and dozens of other countries. Their testimony transformed the trial. It made the abstract into the concrete. It turned statistics into stories. It ensured that the Nazi leaders sitting in the dock could not hide behind bureaucratic justifications or claim ignorance of what their policies had cost. This is their story, and the story of how their voices changed the course of justice. As Allied forces pushed into Germany in the spring of 1945, they began discovering the concentration camps. What they found was beyond comprehension. Bergen-Belsen, as discussed in previous documentaries, held 60,000 survivors and 25,000 corpses. But there were dozens of other camps: Buchenwald, Dachau, Mauthausen, Ravensbrück, and further east, in occupied Poland, the extermination camps where millions had been murdered: Auschwitz-Birkenau, Treblinka, Sobibor, Belzec. British and American forces discovered the concentration camps in the west. Soviet forces discovered the extermination camps in the east. What they found was evidence of an industrial system of genocide unlike anything in human history. The numbers were staggering. 6 million Jews murdered, millions of others, Roma, disabled individuals, political prisoners, Soviet prisoners of war, Poles, homosexuals, systematically killed. But the numbers alone didn't convey the reality. The reality required testimony. It required witnesses who could describe what had happened, who could provide the human context for the statistics. In the immediate aftermath of liberation, survivors began giving testimony. Some were interviewed by military personnel. others by journalists, still others by relief organizations trying to track missing persons and document what had happened. These testimonies were collected, documented, and preserved. They became crucial evidence for the upcoming trials. The Nuremberg trial was officially titled The Trial of the Major War Criminals before the International Military Tribunal. It began on November 20, 1945, in the Palace of Justice in Nuremberg. The city itself had been heavily damaged by bombing, but the Palace of Justice had been carefully preserved. The Allies recognized its symbolic importance. The prosecution team was multinational. Robert Jackson represented the United States. Hartley Shawcross represented Britain. François de Menton represented France. Roman Rudenko represented the Soviet Union. Other nations sent representatives as well. The defendants were 24 of Nazi Germany's most powerful men. Some were military leaders. Others were political figures. Still others were administrators, who had implemented Nazi policy at the highest levels. Hermann Göring was the highest-ranking defendant. He had been Hitler's deputy and head of the Luftwaffe, the German Air Force. He was also one of the architects of the persecution of Jews and had played a key role in early plans for genocide. Rudolf Hess was Hitler's deputy for political affairs. He had been captured in Scotland in 1941 after a failed peace mission. His mental state was questionable throughout the trial. Albert Speer was Nazi Germany's Minister of Armaments and War Production. He was one of the few defendants who would later claim to have been unaware of the full extent of the Holocaust, though his knowledge was debated. Joachim von Ribbentrop was the foreign minister. He had negotiated treaties and coordinated foreign policy throughout the Nazi period. Ernst Kaltenbrunner was the head of the Reich Security Main Office, RSHA, the organization that oversaw the Gestapo and the SS. He had direct responsibility for the concentration camp system and the Holocaust. These were just 5 of the 24 defendants. Each held significant power in the Nazi regime. Each had made decisions that affected millions of lives. But how would they be convicted? What evidence would prove their guilt? Documents alone might not be sufficient. Nazi leaders had been careful to hide their crimes. Orders for genocide were often couched in euphemistic language. The decision-making process was deliberately obscured. What was needed was testimony. Living witnesses who could describe what had happened. Survivors who could connect the abstract decisions made in Berlin to the concrete suffering they had experienced. This is where the 3,000 survivors would become crucial. The prosecution team at Nuremberg knew that survivor testimony would be essential to their case. They began organizing the collection of witness statements in 1945, even before the trial began. Teams of investigators were sent across Europe and to displaced persons camps where survivors had gathered. They conducted thousands of interviews. They asked survivors to describe what they had witnessed, what they had experienced, and what they knew about specific Nazi officials' roles in crimes. The process was painstaking. Many survivors were traumatized and struggled to articulate what had happened to them. Some spoke multiple languages, requiring translators. Some were so emotionally damaged they could barely speak at all. But the investigators persisted. They recorded testimony on film and in written form. They collected affidavits, sworn statements that could be presented in court even if the witness could not appear in person. The collection process revealed crucial patterns. Survivors could describe specific decisions made by specific Nazi leaders. They could connect the top-level Nazi leadership to the ground-level reality of persecution and genocide. For example, survivors could testify about the systematic nature of deportations. They could describe how Jewish communities were ordered to register, how they were informed they would be relocated, how they were loaded onto trains. This testimony established that what happened was not spontaneous violence, but a carefully planned system ordered from the highest levels of government. Survivors could testify about the conditions in concentration camps. They could describe the deliberate starvation, the forced labor, the medical experiments, the executions. This testimony connected the camp system to the decisions made by Nazi leaders in Berlin. Survivors could testify about the creation of ghettos, sealed-off areas where Jewish populations were concentrated before deportation. They could describe how officials like Ernst Kaltenbrunner oversaw these ghettos, how decisions made in Berlin directly affected conditions on the ground. By the time the Nuremberg trial began, the prosecution had collected testimony from thousands of survivors. Not all of them would testify in person. That would have been logistically impossible. But their statements were documented, and many would be presented to the court. The defense team for the Nazi officials argued that witness testimony from survivors should be limited. They claimed that survivors were biased, that they might exaggerate or misremember, that their emotional trauma made them unreliable witnesses. But the prosecution argued, successfully, that survivor testimony was essential. Without it, the abstract machinery of genocide would remain abstract. With it, the court could understand what the defendants' decisions had actually meant for real people. The legal framework for accepting survivor testimony was established by Chief Justice Robert Jackson in his opening statement. Jackson argued that the court should accept not just documentary evidence, but also the testimony of those who had experienced the consequences of Nazi policy. This was a crucial legal innovation. It established the principle that victim testimony was as important as documentary evidence. It affirmed that the lived experience of those who had suffered carried weight in determining guilt. The testimony would come in various forms. Some survivors would testify in person, describing their experiences to the court. Others would submit written statements that would be read into the record. Still others would be shown in films or photographs, making their testimonies visible to the court and to the world. One particularly powerful form of testimony involved the Nazis' own documents. The prosecution had captured thousands of Nazi documents, many of which referenced specific officials' involvement in genocide. When survivors testified about what had happened, these documents corroborated their accounts. The effect was powerful. The survivors' testimony and the Nazi documents together created an undeniable picture of systematic genocide ordered from the top. For example, Heinrich Himmler, the leader of the SS, had kept detailed records of his activities. These records showed his involvement in the Holocaust. When survivors testified about the camps and the killings, Himmler's records proved that he had authorized and directed these activities. Similarly, Adolf Eichmann, the architect of the Holocaust's logistics, had documented his activities extensively. His records showed how he had coordinated the deportation of millions of Jews to extermination camps. When survivors testified about being deported, Eichmann's records proved that he had personally arranged their deportations. The combination of survivor testimony and Nazi documents created overwhelming evidence of guilt. But the testimony also served another purpose, beyond legal proof. It ensured that the world understood what had happened. It transformed the Holocaust from an abstract historical fact into a human reality. November 21, 1945. The trial's second day. Chief Prosecutor Robert Jackson delivers his opening statement. It is one of the most important legal speeches of the 20th century. Jackson argues that the trial is not about revenge. It is about establishing a principle, that nations and their leaders cannot commit genocide and escape accountability. He calls the Holocaust a crime that transcends national boundaries, a crime against humanity itself. He announces that the prosecution will present testimony from survivors. He prepares the court for what they will hear. In the weeks and months that follow, survivors take the stand. Dr. Ella Lingens-Reiner was a Polish physician and political prisoner who had been imprisoned at Auschwitz. She testified about the conditions in the camp, the deliberate starvation, the medical experiments. Her testimony was clinical and precise. She described what she had observed as a medical professional, but also the human suffering she had witnessed. Rudolf Hess and Alfred Wetzler were two Hungarian Jews who had escaped from Auschwitz-Birkenau in 1944. They provided detailed testimony about the extermination process at Auschwitz. They described the gas chambers, the crematoriums, the systematic process by which Jews were selected for immediate death upon arrival. Their testimony established that the Nazi leadership knew exactly what was happening at Auschwitz, that it was an extermination camp, not a labor camp. Marie-Claude Vaillant-Couturier was a French resistance fighter who had been deported to Auschwitz and then to Ravensbrück. She testified about the conditions in both camps, about the deliberate starvation and brutality. Her testimony was particularly powerful because she was articulate, educated, and could communicate clearly to the court the reality of what she had experienced. Jehiel Denur was a Polish Jew who had survived Auschwitz. When he took the stand to testify, he suddenly collapsed, overwhelmed by the emotion of describing his experiences and seeing the Nazi officials who had caused his suffering sitting in the dock. His collapse was emotionally powerful. It demonstrated the depth of trauma that survivors carried. Szymon Datner was a Polish Jew and historian who testified about the massacre at Jedwabne, where Polish townspeople, under Nazi influence, had murdered their Jewish neighbors. His testimony documented the ways in which local populations had participated in genocide. Hermann Göring was a German businessman who had witnessed massacres of Jews in Ukraine. His testimony was particularly significant because he was German, not a victim but a witness to Nazi crimes. His testimony demonstrated that even some Germans recognized that what was happening was wrong. Abram Bergson was an American economist who had studied the Soviet Union before the war. He testified about German atrocities in the Soviet Union, particularly the massacre of Soviet prisoners of war by German forces. As survivor after survivor testified, a pattern emerged. The testimonies were consistent. They corroborated each other. They described a systematic process of persecution and genocide that had been coordinated from the top levels of the Nazi government. The testimonies also made the defendant's guilt personal. When survivors described being loaded onto trains, they were describing something that Ernst Kaltenbrunner had organized. When they described arriving at Auschwitz and seeing the selection process, they were describing something that Rudolf Hess had knowledge of. When they described starvation and disease, they were describing consequences of policies that Hermann Göring had approved. The defendants listened to these testimonies. Some showed no emotion. Hermann Göring took notes, preparing his defense. Others became visibly disturbed. When Lingens-Reiner testified about medical experiments at Auschwitz, some defendants turned away, unable to listen. The testimonies were devastating to the defendants' defense arguments. Several had claimed they didn't know about the concentration camps. The testimonies proved this was a lie. The camps were well known. Their purpose was well known. And the conditions were deliberately created by policy decisions made at the highest levels. Others had claimed they were just following orders, that they had no choice. The testimonies proved this was also a lie. The Holocaust was not an inevitable consequence of war, but the result of specific decisions and policies implemented by specific people in positions of power. The cross-examination of witnesses was vigorous. The defense lawyers tried to undermine the credibility of survivors, suggesting they might be mistaken or biased. But the survivors held up well under cross-examination. Their accounts were detailed, consistent, and corroborated by documentary evidence. Over the course of the trial, approximately 143 witnesses testified in person. Additionally, the testimony of many more survivors was presented in the form of written statements, affidavits, and filmed depositions. The total number of survivor testimonies considered by the court exceeded 3,000. These testimonies covered every aspect of Nazi crimes: the persecution of Jews, the killing of Roma, the murder of political prisoners, the enslavement of Soviet prisoners of war, the medical experiments, The starvation in concentration camps. The testimonies established beyond doubt that 1. The Nazi leadership knew about the Holocaust. 2. The Holocaust was the result of deliberate policy decisions made at the highest levels. 3. The concentration camp system was not an improvisation, but a carefully planned system of persecution and murder. 4. The conditions in the camps, starvation, disease, brutality, were deliberately created to cause suffering and death. These conclusions, supported by 3,000 survivor testimonies, would form the foundation for the convictions and sentences. September 30 and October 1, 1946. After 10 months of testimony, evidence presentation, and deliberation, the International Military Tribunal delivers its verdicts. 24 defendants sat in the dock. The verdicts would determine their fates. Hermann Göring, found guilty on all 4 counts, sentenced to death by hanging. Rudolf Hess, found guilty on 2 counts, sentenced to life imprisonment. He would spend the rest of his life in prison, dying in 1987 at age 93. Joachim von Ribbentrop, found guilty on all 4 counts, sentenced to death by hanging. Ernst Kaltenbrunner, found guilty on all 4 counts, sentenced to death by hanging. Albert Speer, found guilty on 3 counts, sentenced to 20 years imprisonment. He would serve his sentence and upon release become a prominent author and speaker about the Nazi period. Wilhelm Keitel, found guilty on all 4 counts, sentenced to death by hanging. Ioannis Metaxas, acquitted on all counts. This verdict was controversial, as some argued he should have been convicted, and so on through all 24 defendants. In total, 12 defendants were sentenced to death by hanging. 7 received prison sentences ranging from 10 years to life. 3 were acquitted. The death sentences were carried out on October 16, 1946. The defendants were hanged in the Nuremberg prison gymnasium. Hermann Göring, the highest-ranking defendant, cheated the executioner by committing suicide in his cell hours before his scheduled execution, swallowing a cyanide capsule he had somehow hidden. The other 11 went to their deaths. Some showed remorse. Others remained defiant. Most showed no particular emotion, apparently resigned to their fate. The hangings marked the end of the Nuremberg trial, though more trials would follow as lower-ranking Nazi officials were prosecuted. But the verdicts and sentences would not have been possible without the testimony of the 3,000 survivors. The judges explicitly noted in their verdicts that survivor testimony had been crucial to proving the defendant's guilt. The testimony had established that the defendants knew about the Holocaust. It had established that they had the power to stop it or mitigate it, but chose not to. It had established that their decisions directly caused the suffering and deaths of millions. The role of survivor testimony in securing these convictions established a crucial legal precedent. In crimes against humanity, the testimony of victims carries weight equal to documentary evidence. The lived experience of those who have suffered is essential to proving guilt and determining punishment. This precedent would shape international law for decades to come. It would be applied in subsequent trials, the Tokyo trials of Japanese war criminals, the trials of Cambodian perpetrators, the trials of Rwandan perpetrators, the trials of Bosnian war criminals. The principle became established in international law. Those who commit crimes against humanity can be held accountable, and the testimony of survivors is essential to that accountability. But the immediate impact was on the 12 men who were executed. Hermann Göring's death, by suicide rather than execution, was controversial. Some saw it as a final act of defiance. Others saw it as an act of cowardice. His last act was to deny the executioner the satisfaction of carrying out the sentence that survivor testimony had made inevitable. The other 11 were hanged. Their deaths marked the end of an era. The era of Nazi leaders who had thought themselves untouchable, who had believed they could commit genocide and escape accountability. They had been proven wrong. And it was the voices of survivors that had proven them wrong. The Nuremberg trial was not the only trial of Nazi criminals. It was, however, the most significant and the most influential. After the main Nuremberg trial concluded, there were 12 additional trials held in Nuremberg from 1946 to 1949. These trials prosecuted lower-ranking Nazi officials, doctors who had conducted experiments, judges who had upheld Nazi laws, industrialists who had profited from slave labor. The first of these additional trials became known as the Doctors' Trial. It prosecuted Nazi doctors who had conducted medical experiments on concentration camp prisoners. The trial lasted about 9 months and resulted in convictions of 16 of the 23 defendants. This trial was particularly important for medical ethics. It established the Nuremberg Code, a set of principles governing ethical human experimentation. The code stipulated that research subjects must provide informed consent, that experiments must benefit society, and that researchers must minimize harm. The Nuremberg Code remains the foundation of modern medical ethics. It was directly inspired by the testimony of survivors who had been subjected to medical experiments. Other trials prosecuted Nazi judges. One trial focused on judges who had upheld Nazi racial laws and had sentenced innocent people to death. The testimony of survivors and of those persecuted by Nazi courts was essential to proving their guilt. Other trials focused on Nazi industrialists. Companies like IG Farben and Krupp had profited enormously from the Nazi regime. They had used slave labor from concentration camps. Survivor testimony was crucial to proving these companies' complicity in Nazi crimes. The total number of people tried at Nuremberg in the main trial and the subsequent trials exceeded 100. The total number of survivor testimonies presented at all these trials exceeded 3,000 in the main trial alone, with additional thousands presented in the subsequent trials. Beyond Nuremberg, other nations held their own trials of captured Nazi officials. France tried and executed French collaborators, as previously discussed. Austria tried Nazi officials who had operated in Austria. Poland tried Nazi officials who had operated in Poland, particularly those involved in the Holocaust and the massacre of Polish citizens. Yugoslavia tried Nazi officials and collaborators who had operated in Yugoslavia. The Soviet Union held trials, though often these were show trials with political purposes beyond simple justice. The combination of all these trials, Nuremberg and the subsequent trials across Europe, ensured that at least some Nazi perpetrators faced justice. The testimony of survivors in all these trials established patterns, corroborated accounts, and made possible the convictions that would not have been possible based on documentary evidence alone. But the trials also had limits. Many perpetrators were never tried. Many escaped to South America or other countries. Many died without facing justice. Even among those who were tried, many received relatively light sentences. Some were released in the 1950s as Cold War politics took precedence over Nazi-era justice. Nonetheless, the Nuremberg trials and the subsequent trials established something unprecedented: the principle that nation-states and their leaders could be held accountable for crimes against humanity. The principle that individual responsibility extended beyond military necessity and orders. The principle that survivor testimony was essential to justice. These principles, established largely through the testimony of 3,000 survivors and thousands more, would shape international law for the rest of the 20th century. In recent decades, survivor testimony has continued to be crucial in prosecutions of war criminals. The trials of Bosnian war criminals, Rwandan perpetrators, Cambodian perpetrators, and Syrian officials have all relied heavily on survivor testimony to establish guilt and determine appropriate punishment. The principle that survivor voices matter, that the testimony of those who have suffered is essential to justice, remains one of the most important legacies of Nuremberg. The last surviving witnesses to the Nuremberg trial are now in their 90s or older. Many have already passed away. Within the next decade or two, there will be no survivors of the Holocaust still living to testify about what they witnessed. This reality gives urgency to the preservation of survivor testimony. Organizations like the Shoah Foundation, founded by Steven Spielberg, have recorded video testimony from thousands of Holocaust survivors. These recordings preserve their voices and their stories for future generations. The testimonies recorded at Nuremberg and in the decades since have become irreplaceable historical documents. They provide details that no historical text could capture. They provide emotional truth that statistics cannot convey. Modern historians rely on survivor testimony to understand the Holocaust. It is the primary source that shapes our understanding of what happened. But survivor testimony's importance extends beyond historical documentation. It remains crucial to ongoing justice efforts. In the 1990s, survivor testimony was essential to the International Criminal Tribunal for the former Yugoslavia, which prosecuted Serbian, Croatian, and Bosnian war criminals. Survivors testified about massacres, ethnic cleansing, and sexual violence. In the 2000s, survivor testimony was central to the International Criminal Tribunal for Rwanda, which prosecuted those responsible for the Rwandan genocide. Survivors testified about the systematic massacre of Tutsi people by Hutu militias and government forces. In the 2010s and 2020s, survivor testimony has been crucial to prosecutions of Syrian officials for crimes against humanity during the Syrian civil war. Survivors have testified about torture, extrajudicial executions, and systematic violations of human rights. The principle established at Nuremberg that survivor testimony is essential to proving guilt in crimes against humanity has become embedded in international law. It is recognized in the statutes of international courts. It is accepted as standard practice in war crimes prosecutions. But the principle was not always accepted. The Nuremberg trial had to establish it. The prosecution had to argue that survivor testimony was reliable, that it was relevant, that it carried legal weight. This was a significant innovation. In previous legal contexts, the testimony of victims had sometimes been considered unreliable or emotionally biased. The Nuremberg trial established that victim testimony, when carefully gathered and presented, could be as reliable as any other evidence. This principle has profound implications. It means that those who suffer crimes have a voice in determining justice. It means that the experience of victims matters legally, not just morally. It means that the powerful cannot commit atrocities and hide behind bureaucratic justifications or claims of ignorance, because survivors will testify about what actually happened. The 3,000 survivors who testified at Nuremberg did more than just secure convictions of 12 Nazi leaders. They established a legal principle that would shape international justice for generations. In doing so, they transformed the relationship between victims and justice systems. Before Nuremberg, victims were often peripheral to legal proceedings. Their role was to provide information, but their emotional experience, their lived reality, was often not central to legal proceedings. After Nuremberg, survivor testimony became central. The voices of those who had suffered became the foundation upon which justice could be built. This transformation was not just legal, it was moral. It affirmed that the suffering of victims matters. It affirmed that the truth of their experience, told in their own voices, is essential to justice. The descendants of Holocaust survivors continue to emphasize this point. They argue that the responsibility of each generation is to listen to survivor testimony, to preserve it, to ensure that the world remembers not just the facts of the Holocaust, but the human reality of what survivors experienced. This responsibility extends beyond the Holocaust. As new atrocities occur, in Cambodia, Rwanda, Bosnia, Darfur, Syria, the voices of survivors become crucial to both historical understanding and legal accountability. The principle established at Nuremberg through the testimony of 3,000 survivors remains as vital today as it was in 1945. Today, as the last Holocaust survivors reach the end of their lives, there is a race to record their testimonies before they are gone forever. The Shoah Foundation and other organizations work to ensure that these testimonies are preserved. Educational institutions use these testimonies to teach students about the Holocaust. Legal scholars use survivor testimony to understand the nature of crimes against humanity. The testimony of 3,000 survivors at Nuremberg did not end injustice in the world. It did not prevent subsequent genocides. It did not ensure that all perpetrators would be held accountable. But it established something crucial: the principle that those who suffer have a voice in justice, that the testimony of survivors matters, that the truth of victims' experiences carries legal weight. This principle, established through the courage of survivors willing to testify against their torturers, remains one of the most important legacies of Nuremberg. It reminds us that justice is not a distant concept administered by courts and judges. Justice is personal. It is about recognizing the suffering of victims, validating their experiences, and ensuring that those responsible for causing that suffering are held accountable. The 3,000 survivors who testified at Nuremberg were not just witnesses. They were participants in the creation of a new form of justice, a justice that centers the voices of victims, a justice that recognizes that accountability requires listening to those who have suffered. That legacy continues today. It will continue as long as survivors and their descendants insist that their voices matter, that their experiences must be remembered, that the perpetrators of atrocities cannot escape accountability as long as there are survivors willing to testify about what happened. The Nuremberg Trials ended more than 75 years ago. Most of the defendants and most of the survivors are gone, but the principle they established remains vital. It reminds us that justice is not about revenge. It is about truth. It is about ensuring that the voices of those who have suffered are heard. It is about affirming that their experiences matter, that their testimonies matter, that their demand for accountability will be answered. This is the legacy of the 3,000 survivors who testified at Nuremberg. This is how they changed the course of justice, not through force or violence, but through the simple act of telling the truth about what they had witnessed and endured. Their voices, preserved in transcripts and recordings, continue to speak for justice. They continue to demand accountability. They continue to remind us that survivors matter, that victims matter, that their testimony is the foundation upon which all justice for crimes against humanity must be built.